Good morning, everybody. Welcome to our mobile home town hall presented by GSMOL. I would like to introduce our corporate counsel, Bruce Stanton.
Thank you very much, Ann. Good morning, Ann. Good morning, Martha. And good morning to all of you. We have 55 participants I see from my Zoom screen, so that is fabulous. Glad you could all join us. Hope everybody is having a good spring and early summer so far. The weather's getting better for all of us, so it's going to be good to move into summer. And this is our annual sort of late spring, early summer town hall that's sponsored by the Golden State Manufactured Homeowners Education Fund, which is the nonprofit organization that works in conjunction with GSMOL on behalf of homeowners throughout California. So happy to be here with you. I think my opening remarks will be briefer than maybe they've been in the past. I don't have any specific topic to discuss other than just giving a brief legislative update, legislative overview of where some of the bills stand and what's turning out to be an extremely busy legislative season. GSMOL at this point has two sponsored bills. The first is an assembly bill, which is AB 2022, and this is by Assembly Member Dawn Addis, ADDIS. AB 2022 is a bill that would require a mobile home park owner to comply with more specific obligations, if you will, in connection with emergency procedures. The existing statutes in the Health and Safety Code require the park owner to adopt what's called an emergency preparedness plan. In other words, a plan where the emergency exits are in the park, how are we going to evacuate folks in the event of an emergency, how is the park owner going to respond in the event of emergencies, such as earthquakes or fires. One of the issues that's come up is that if park owners don't file these plans, don't make them available like they should, don't put proper procedures into place in terms of inspecting their fire hydrants, for example, to make sure the fire hydrants pass certification tests and that they're operational in the event that they're needed. One of the issues that we've noticed is that the Department of Housing and Community Development doesn't really enforce those provisions in the way that we believe they should, specifically that they would have the ability to tell the park owner, look, if you don't comply with this, we're going to initiate proceedings to terminate or suspend your permit to operate the park. And we had parks that had long overdue non-compliance with certain issues. So this bill is actually going to require for the first time that park owner or manager actually submits an attestation that says they're attesting that there has been compliance with all of the requirements of the Health and Safety Code. And it would require or allow the refusal to issue or renew a permit to operate if violations of this section are not corrected within 60 days. So the idea is to put a lot more incentive, if you will, and in some cases pressure on park management to comply with these provisions. The bill passed through the Assembly Housing Committee by a 7-1 vote with one abstention on April 24th and went to Assembly Appropriations. That hearing occurred on May 15th, and my recollection is the bill also passed out of that committee and would be then heading to the floor for a vote. So that's where that bill now stands. I believe that's the most up-to-date status on AB 2022. The second bill that GSMOL is sponsoring this year is SB 1408 by Senator Roth. And that bill is very pretty simple concept or topic, I think, compared to some of the legislative matters that can be pretty complex that we deal with. But it's basically just saying that management cannot remove a vehicle from a park merely because the vehicle is advertising some kind of employment or trade or services. If that vehicle is parked in the homeowner's driveway. In other words, if you have a company truck that you drive that's got advertising on the side of it, if you operate a business, as long as you're not operating the business within the park, that's a whole, different can of worms. But just driving the vehicle to and from a place of business and parking it overnight in the carport should not be enough cause for management of the park to say, well, this is a work vehicle. It looks like you're conducting a business in the park. If you park merely because you parked the vehicle in the park and we want it removed, this bill will prohibit that. That's again SB 1408. Checking on the status of that bill by Senator Roth. That was referred out to the Assembly Housing Committee on May 6th after it passed Senate Judiciary by an 11-0 vote on April 2nd. And it was on the Senate floor consent calendar on April 11th and passed with a vote of 39-0 with one abstention. So it's gone through the Senate successfully and it's now in the Assembly. There's a few other bills that GSMOL is not sponsoring that we've been monitoring pretty closely. And that includes AB 2539 by Assemblymember Conley. And this is a bill that would allow for right of first refusal for mobile home residents to purchase their park. You might be aware that in the mobile home residency law in Civil Code 798.80, there's a provision that allows residents to form a committee and give notice to park management of this committee. It does not have to be an incorporated entity. It could be not an unincorporated simple committee that is the available communication point to get notification if the park is going to be listed on the open market for sale. And that's currently, and it has been that way for many years, the only real protection, if you will, that residents of a park have from the park being sold. The problem with the statute right now is the way that it's worded. That notification only has to be given if the park is going to be listed for sale. And so many times park owners are selling the parks without putting them on any listing. They're just selling them privately. They just put out, the feelers into the sort of community of potential buyers that they know about. They get a buyer, they get into contract, and residents don't have any knowledge, even if they have one of these committees, they don't have any knowledge sometimes that the park is being sold until it's actually happened. And sometimes they don't even know until suddenly the new owner shows up and says, hey, we bought the park 2 weeks ago and we're going to have a first meeting with you, or here's the new contact information for park management. So the idea behind this bill would be to actually go beyond just a simple notification protection and give residents a right of first refusal if the park is going to be sold. That bill, and one of the questions that was submitted today is what happened to AB 2539. Basically, that bill is being held under submission in the committee. And that means that there were not enough votes to get the bill out of committee, but held under submission, as I understand it, and I'm not, our lobbyist, I'm not familiar with these terms the way any lobbyist would be, or somebody who works full-time in the Capitol. But my understanding is held under submission is a designation that means there is a desire to continue to work on the bill, and no motion is made to move the bill out of committee because it probably would fail but the bill could be set for another hearing. And that would give time for further reflection or communication about the substance of the bill or for amendments to be taken. So the bill's not dead at this point, apparently, but it has not had enough votes to get out of assembly housing, and that's where that bill stands. There's another bill that we have been working with Senator Laird on, and that's SB 1190. And SB 1190 is specifically related to solar energy. Currently, under the law, there is no specific right, if you will, or there's no specific references to solar energy installation in mobile home parks. There is a provision in the law that talks about solar energy installation in multi-family or high-density housing communities, such as condominiums or common interest developments. But mobile homes are not mentioned therein. And so the idea behind this bill would be to put something into place that would allow residents to actually opt for solar installation on their homes. We know very well, of course, that park owners are installing solar energy in the common areas of the park. That might be the clubhouse roof. It might also be that covers are being installed over guest parking areas. I know I'm aware of in a number of parks that have those, what is called a solar array. We're going to have to make sure I think, Ann, we have some new folks coming on that need to be muted there. Thank you. So SB 1190 is meant to address that issue. And I'm not sure what the current status of that is. I'm checking for my update here, and I'm not sure that it's even on the list for whatever reason. So I can't give you a recent update on that, but we have been working on the language and working with Senator Laird's office on that. There's a couple of other bills in the Assembly side by Assemblymember Rendon, and we've actually, even though we don't have a sponsorship of those bills, we've been working with the language on those. One of them is preventing a park owner from evicting residents while there is no valid permit to operate, which only makes perfect sense, right? If the park is under suspension by Department of Housing because of code violations or something, they shouldn't be able to evict residents when they can't even really operate the park. There's another that's AB 2373. AB 2399, also by Assemblymember Rendon, is a notification of rights bill, and it just adds some specific language in the mobile home residency law that must be disclosed to any new purchaser of a home about the mobile home residency law protection program, the MRLPP. And we've added some paragraphs that pretty much come right out of the Department of Housing's website that describe the MRLPP program and give contact information so that new residents moving into a park know that that program is available and would have a source to look at in terms of how to contact and make a claim, file a complaint with MRLPP if they needed to do so. There is another bill that we've worked on some language, AB, actually it's a Senate bill, SB 1108 by Senator Ochoa Bogg. And this was a bill that we had some concern about in terms of violations that come to residents after the Department of Housing inspects a park under what's called the MPM inspection program. Under the more updated regulations or procedures that Department of Housing and Community Development has put into place following an audit some years ago, the program has been refined, fine-tuned, and is sort of been relaunched, I think, with a fresh wind and some new incentive and accountability to try to meet the goal of inspecting all the parks in the state once every 7 to 10 years, putting at the top of the list those parks where violations have been alleged or complaints have been filed, and they're the older parks that are in worse condition. And one of the concerns that we have, as this bill was addressing some of that, is how notification is given, or when notification is given, if residents are cited for violations. We know that when the inspectors come through the park, they're looking at everything. So they're not only looking at the common areas like the clubhouse grounds and the swimming pool and all the other amenities, but they're also going to be inspecting individual spaces. And homeowners can get cited for that, just like the park owner can get cited for its violations that it has jurisdiction and control over. Well, what we don't want to have happen is to have those violations essentially weaponize the ability of the park owner to then start eviction proceedings because somebody has been cited. And so, as we've been tracking this bill, what we wanted to ensure was that when homeowner violations are noticed, the first violation notice that puts the homeowner on notice and gives time, typically, if it's not an imminent hazard, up to 90 days to correct the violation. We don't want park management to get that notice, that initial notice. They should only be entitled to notice after there's a second reinspection and a second notice for noncompliance. Because at that point, maybe we've got an issue where we've got a non-compliant homeowner. He either doesn't know how to, they don't know how to fix the violation, or they're just refusing to. But the initial notice will not be, under this bill, going to park management. That's been placed in a suspense file, this bill. So I'm not sure where that's going to go. It might be that that's going to turn into a 2-year bill. So we'll just have to see about that one. And I think the only other one that I wanted to mention was a bill by Assemblymember Pellerin. This is a bill that appears to have been sponsored by the manufacturers, the Mobile Home Manufacturers Association. And it's, I guess you could say, making the process easier for a park owner to add a new space in the park and place a new home on that space. Not anything that we are directly involved with, but the concern was, what's the impact of that when we have lot lines being moved? And so many times when a park owner is adding a space or adding a lot, they're shoehorning in the new home, they're moving lot lines of the existing space sideways out to allow for adequate space for the new home to be sited. And that's happening with no proper procedure for lot movement. Management suddenly just goes out, residents just see, the lot lines are being moved unilaterally. And of course, under the health and safety code, lot lines cannot be moved legally without the permission of the resident, without the permission of the park owner, and without an application being filed with Department of Housing in Sacramento, HCD. This bill, we've added language that indicates that adding new lots doesn't mean that we're not going to follow those regulations. And the new lot lines, or the new lots, can only be established when the proper procedures are followed under the health and safety code for moving lots. The other language we added was based out of our concern that by adding lots in some jurisdictions with mobile home rent ordinances, if you added new lots and they're new construction, so they're going to be exempt from rent control for the first 15 years of their existence, we were concerned that in those jurisdictions that say that you need to have a minimum number of lots within the city or county covered by the ordinance. And if they're not covered, the ordinance could trigger the ordinance being rescinded. The idea, I think, behind those provisions was if a vast majority of spaces get covered by long-term leases, why do we need rent control? They're all covered by leases. Well, we don't want adding new lots to in any way impact that. In other words, the new lots come in, they're exempt as new construction, so they're not covered, and then some kind of percentage trips, and the ordinance goes into a suspension. So the language we've added says that none of these new lots that are added are going to affect those percentages, so that no trigger threat to rent ordinances would occur. So that's my summary for you today of legislative matters. Again, I'm not the lobbyist. The GSMOL has an LAT that's very active, that meets weekly with our lobbyist, Esperanza. And I would just suggest anybody who has any more specific questions about legislation, it's possible I could answer them. But my main role is to work on the language here, work with committee staffs along with Esperanza, and work with the council for the different committees, the legislative council on language. I'm really a wordsmith in that regard. So I may not have the answer for you on a lot of the questions that you might have about some of the nuances or specifics, or especially the procedures with the bills. I'm not really involved in the procedure for getting them passed as much as I am the language part. All right, so let me go to the questions now that have been submitted in advance, and let's see if we can tackle some of these. I got about 10 or 15 questions, and I think we can go through them fairly quickly. Question number one, we have a management company that has decided to start charging as of January without notification, which is an important part of the question, $5.25 a month to process our lot payments due to the fact that the cost of office supplies have increased. Is this a legal charge? And what can we do to stop the charge? Well, the answer to this question is found in the mobile home residency law. Specifically, it's Civil Code 798.31. And 798.31 says, very succinctly, a homeowner shall not be charged a fee for other than rent, utilities, and incidental reasonable charges for services actually rendered. Well, what does that mean? Services actually rendered. I think it's pretty clear that there has to be some kind of specific service, such as, I suppose, if a park wanted to add security services to the park and patrols, and they said, we'll add this, but we're going to start charging, to defer some of the costs for it. We're going to start charging for this extra service that we're providing. The example that I remember always hearing about was if the park constructed a dog run within the park for residents to use with their dogs. Well, for each resident who has a dog, they could be charged for that service because, again, it benefits them. And the charge would have to be incidental. My concern with this is if a park owner can simply say, the cost of something has increased, in this case, the cost of paper or ink for my printer or whatever it might be, so I'm just going to start charging you some amount of money to further defer the cost of my office operations. I think clearly that is not a permissible charge. That would open the door, in my view, to all sorts of charging. If you could simply say, anything I do in connection with management or ownership of my park is a service rendered, well, then they could charge for anything and everything. And pass-throughs are legal. make no mistake about it, the cases that have been decided have determined that pass-throughs of certain charges are legal if a rent ordinance allows them or if a rental agreement allows them. But to just say we're going to start ramping up these charges, I think that's a clear violation of the mobile home residency law. The other thing I'll add to that is this question says it was done without notification. The very next section of the MRL 798.32 says that a homeowner shall not be charged a fee for services actually rendered that are not listed in the rental agreement to the homeowner if the fee or charge has, unless they have been given written notice at least 60 days before imposition of the charge. Again, even if this was a reasonable incidental charge for a service actually rendered, there has to be a 60-day notice preceding the charge. That apparently didn't happen here. It's a second reason why, in my view, it's an improper charge. Next questions come from Seaview Park. Is there any way that we can require or ask our park to give us an invoice or a receipt for our rent each month? This is a question that I've actually had asked fairly recently a number of times, and I've tried to do some cursory research. I have found no law in California that requires a park owner to give a receipt for rent payment. Now, I would say that because a park cannot refuse to accept payment by some non-electronic means, in other words, they can't just have that online portal and say, all of your payments have to go through the portal. We're not going to take cash. We're not going to take checks. We're not going to take money orders. You have to go electronic. Well, there's a law that says they can't do that. They have to still allow for some method of non-electronic payment. Well, that would be a check or a money order or a cashier's check where you get a carbon. And that's basically your receipt. That shows that you obtained the funds, and it doesn't, of course, give you the same sort of satisfaction or evidence you would have if you went into the office, handed the check to the manager, and had some kind of stamp put on a copy of the check or a receipt actually written out. But I don't know that there's any law that would require that at this point. As far as an invoice, getting a rent bill, it's kind of amazing to me that especially in a park that's sub-metered for energy, where the park is reading the gas, electric, or water meters, I'm not sure how a park could get away with not giving you some kind of a billing, because until you get a bill, you're not going to know what you're supposed to pay, because water consumption, gas, or electric usage is going to vary from month to month. You're just not going to know. So it would make no good business sense, in my view, for a park not to give an invoice. I think the only way they get away with that is if there is no sub-metering. But even then, when they're charging some prorated amount for utilities, there has to be a calculation for that. So again, I'm not sure that I've seen a law that says a landlord must give an invoice, but practically speaking, if they don't, I don't see how they could really enforce the payments in the correct amount. Maybe it's something for us to look at a little more deeply if we seem to have more and more reluctance of parks to give invoices. I guess they're going paperless, right? I guess that's the word that we're hearing, the buzzword we're hearing. But anyway, that's all I could tell you about that. I think it's maybe something we need to keep monitoring to see how widespread the practice might be. A part of the same questions from this park was, we drop our check in an insecure box on the edge of the garden shed, and then the manager picks it up whenever he wants, deposits the check whenever he wants, and we have no way of proving we've paid our rent. I guess I would ask, is that the only method by which the residents can tender their checks? In other words, nobody's in the office. that maybe there is no office, there's no, the manager lives in maybe in a, elsewhere in the park in their own home, but there's no place there to deliver checks. I have a lot of concern that if the only way to drop a check off in this park is some kind of box at the edge of a garden shed, which doesn't sound real secure, I think the park owner needs to be notified about this, and or the offsite management company. And residents, I understand, are going to be concerned and say, well, how do we know that they're going to say they got it on time? Well, that's going to depend upon really what the conduct is going forward of management. If people start getting these allegations, oh, your rent came in late, then I think, yeah, that's when you need to start having a powwow with them and going up the food chain to the park owner, all the way to the park owner if you have to say, look, this isn't working. I mean, we're tendering our checks in a timely manner, and now we're getting these allegations that we haven't paid our rent. That would be a concern for me. But I will say this, it's going to be just as difficult for the park owner to go in court and allege they didn't get the check on time, given this very slipshod method of taking the checks. It'll be just as difficult for them as it will be for the residents to prove when they put the check in the box. And the landlord has the burden of proof. So if I'm a judge and I'm hearing these facts and I'm hearing that, yeah, the only way we take checks is in a box attached to a garden shed, and the manager may or may not even be checking the box every day, I'm going to say to the park management, how can you prove your case? How on earth can you prove that the resident didn't put their check in that box before the 5th of the month or by the 5th of the month? So I think it's a problem for both sides. So I think that's all I can say about that. The next question is, it's a reference actually to the code section that I read a little while ago, the 798.31, that says only rent, utilities, and incidental charges for services rendered can be charged. And this homeowner is asking, there doesn't seem to be any provision in the MRL that allows pass-through costs for capital improvements or for typical maintenance costs. These are operational costs. The key word in this section 798.31 is services rendered, and I don't believe that applies to capital improvements. Is that correct? I would say for the most part, yes, that is correct. Capital improvements are not services rendered, typically. Capital improvements are repairs, modifications made to the infrastructure of the park, the roads, the perimeter fences, the clubhouse roof, or new things that are installed in the park, new roadways or new buildings. That's capital in nature. It's not ordinary maintenance. The ability of a park owner to pass those things through is completely separate from 798.31. And as I mentioned a moment ago, there are appellate court cases. I actually argued a couple of them unsuccessfully back in the 1990s. But these cases, there's 2 appellate court cases and 1 California Supreme Court case that all validate pass-throughs. And they all say that if a rent ordinance or if a rental agreement authorizes pass-throughs for things like property tax increases, in one case, or capital expenditures, that those are not illegal. Those are not on their face invalid. And that's why a number of rent ordinances actually have capital improvement pass-through provisions in them that allow for a whole procedure for the park owner to give the information to verify the expenditures have been made and seek to get a pass-through just for that expenditure. And a lot of people living in parks have pass-throughs added to their rent, either because the rental agreement allows it or the rent ordinance allows it for different kinds of capital expenditures. So I think the question is really getting to the issue of, does 798.31 prohibit pass-throughs for capital expenditures? And the answer is no. The next question is an interesting one because I wasn't really even aware of this legislation. But the question is whether or not the quote, right to dry legislation that's found in the civil code applies to mobile home parks. And there's actually a code section. It's not in the mobile home residency law. It's found in Civil Code 1940, 1940.20. And Civil Code 1940.20 is entitled Tenant's Use of Clothesline or Drying Rack. And after defining what those terms mean, it says that a tenant may utilize a clothesline or drying rack in the tenant's private area. And that means the outdoor area within the premises rented by the tenant that's enclosed by a wall or a fence. And there's no specific application of this to mobile home parks. This is a general landlord-tenant provision. And it says that the tenant can use a clothesline or drying rack if that does not interfere with the maintenance of the rental property, it doesn't create a health and safety hazard, block a doorway, or interfere with walkways or utility service equipment, and the tenant seeks the landlord's consent before putting a clothesline up on a building, and it doesn't, the use of it does not violate reasonable time or location restrictions that the landlord might impose. So I guess the answer is this. I don't see anywhere where this section does not apply to a mobile home park, but the same way it would apply to any tenancy, you have to get the permission of the landlord. We could probably agree that park management may not be able to unreasonably deny consent, and it can't violate those things I just mentioned, health and safety issues, block doorways, interfere with utility equipment. And there has to be some kind of reasonable, or the landlord is allowed, park management in this case would be allowed to put reasonable time or location restrictions, such as if you dry clothes for, during the afternoon, you have to take it down by sunset, or you can't do it here, it has to be here where it's more out of sight. I don't think I've seen evidence in many mobile home parks, to be honest with you, of clotheslines and people drying clothes outside. I think a rack would be a lot more commonly used, just a clothes rack. And I see from the comments, somebody said, hey, I've had a clothesline up for many years, and it's basically permanent. If the park allows it, then in conformance with this particular law, yeah, that can happen, and that's okay. Next question, is it true if you submit a complaint through the MRLPP, that's the Mobile Home Residency Law Protection Program with Department of Housing, and you lose the case, do you have to pay the other party's legal fees? Well, the answer to that is probably yes, because if you're bringing a case for violation of the MRL, the Mobile Home Residency Law, the MRL at the very back end of the law in section 798.85 contains what's called a prevailing party attorney's fee provision. The same kind of provision is always going to be found in written rental agreements or leases. And what that says in 798.85 is, in any action arising out of the provisions of this chapter, meaning any action arising under the Mobile Home Residency Law, the prevailing party shall be entitled to reasonable attorney's fees and costs. And folks, that just means that, if you have a complaint that you file with the MRLPP, you can't resolve it with the park owner amicably or voluntarily. The case gets submitted to a local legal provider, and now you have legal representation. That attorney should be advising you about this, and you have to weigh at that point the strength of the case. Is this going to be a strong case? We think we're going to prove our case. We think we have a better chance of winning the case than losing the case. And if so, then the risk analysis might be that you should proceed, even though there is a risk if you lose that you would pay the other side's fees. The concern here always is the park owner is hiring lawyers who charge a lot more per hour than your attorney's going to charge you. So if you litigate a case and it costs you $5,000 and you lose, you might be liable for $25,000 of the park owner's fees. It's really depending upon who prevails. In other words, who does the court support? In whose favor does the judge or jury rule? In most cases, you have a winner and a loser, and it's pretty easy to determine. Some cases can be harder to figure out, did somebody really prevail? Who prevailed? But yeah, that's the kind of thing I always discuss with any client who is potentially looking at filing litigation. You have to understand that if there is a prevailing party clause and you lose, you could be on the hook to pay, as the loser, the park owner's fees. The next question is regarding the manager training program. Is there any requirement that a person who takes the training has to be the actual on-site manager, or can it be somebody else in the management company? This is referring to a bill that was passed by us a few years ago, Senate Bill 869. And 869 was signed into law by the governor in 2022 and provides for the long-awaited and much desired management training program. But there's a period of time when this is going to be ramping up, and we are now within a year of getting the regulations published by Department of Housing. As a matter of fact, the first set of proposed regulations has been issued by HCD for public comment. And I think those comments are going to be due this coming Friday. And I know I'm going to be submitting some comments on behalf of GSMOL. The regulations need to be in effect by May 1st of next year, 2025, and that's when the program really will commence. This question is asking, well, who gets trained under this program? Does it have to be the on-site manager, or it could be somebody else? And the answer actually is that it's not just the on-site manager. The language of the statute is that it would require at least one person per park employed or acting under contract as on-site or assistant manager, or otherwise acting in an on-site or off-site managerial capacity. So to answer the question succinctly, no, it's not requiring that it has to be the on-site manager, but it has to be one person involved in the management per park. So we're moving pretty quickly through these. I think I have about 4 more. Couple by this particular person. We had our park inspected, and rather than tell residents what they had to do to correct violations, people simply got a letter or a notice. And I'm assuming that when the question is using what they had to do, they're talking about a verbal conversation. In other words, that the Department of Housing inspectors would be going door to door and speaking to people about what they had to do to correct violations. Well, that's not the way that it works. They do the inspection. We don't know if who's going to be home during it. I don't think the inspectors have the ability and time available to go space by space and have conversations with every resident. They're going to notify residents by letters or notices based upon violations on the lot that they see. That's the way the procedure is. A number of times these notices were issued erroneously. Residents had to go through a lot of hoops to resolve the issues. Sometimes the inspector tells people, deal with management to get it handled. And so the question is, it's my belief HCD inspector was unprofessional. What recourse do we have? Well, there's a lot of actual information on the HCD website about these MPM park-wide inspections. And I would say first review all of that and make sure you understand how they're going to occur and how notification occurs. Because again, it's not unprofessional that they didn't talk to people, that there's no obligation to do that. They're going to give the notice in writing. If you think that something was unprofessional, what recourse do you have? Hey, contact HCD, make a complaint. If the inspector was unprofessional, if you think the inspector was improperly notifying park management before they had the ability to do that or the right to do that about a resident violation, make a complaint. Contact your GSMO regional manager. If we're starting to see a pattern here, then we will address it as an organization directly with Department of Housing. And the second part of the question, management continues to be picky about everything from flower choices to shades and awnings. You have to have written permission or a face eviction. When is GSMOL going to do something about unreasonable rules? Well, I mean, that's a really, open-ended kind of question. The word reasonable is there in the section that contains the 7 permissible grounds for evicting a mobile home resident. That's Civil Code 798.56. And subsection D, as in dog, of 798.56, says that management could terminate a tenancy on 7-day notice for violation of a reasonable rule or regulation. I don't know that there's any way to legislate beyond that, unless you're looking at real specific things that it would make sense. Otherwise, you'd have a statute that would be virtually unending if we were going to start saying, let's talk about painting of homes, and let's talk about landscaping, and let's talk about who knows what. The legislature is simply not going to sort of dive that deep or drill that deep into specifics. This is going to have to be undeniably a case-by-case situation. But you have to remember, management always has the burden of proof. And they're going to have the burden of proving not only that the rule is reasonable, but that they've been acting reasonably. And it's my experience that once residents really kind of stand up and stiffen their back and fire back at a park owner who's giving them these irrational or unreasonable demands, that a lot of times the park owner is either going to back down altogether, or they're simply going to say, well, then let's hold off, let's talk about it more, and we'll explain more. I've had a number of cases recently where residents are getting these notices, and once a letter comes from me, things change. And I understand you're saying, well, so you're saying that we have to, this question is saying a resident had to pay $1,000 to a lawyer to fight it. Well, sometimes that's what you have to do. And if residents have a tight budget and they don't have the funds, that's why we have the MRLPP program. Go online to the HCD website and file a complaint. But it's really difficult to legislate reasonableness beyond, what the code says. Again, unless we have something really specific, like, it shall be unreasonable for a rule to prohibit a satellite dish or something like that. Moving on, what action can we take if the park owner refuses to repair driveways, saying, we don't know who may have installed or altered the driveways, and so you're responsible? And this is a question that comes straight out of what we call the tree driveway provision in the MRL, which is 798.37.5. And that provision, which mostly deals with trees, also covers driveways. And it says that management's responsible for the repair, replacement, paving, sealing, and expenses related to the driveway if management installed it. And that includes repair of root damage to driveways and foundation systems. The homeowner is responsible if the driveway was originally installed by the homeowners. So the question is, how do we determine that? Again, management has the burden of proof. If they just say, well, we don't know who installed it, so we're going to assume we didn't, and you're responsible, I would say that's putting the cart before the horse in some senses, because it's management who really has the initial burden of showing when the park was built, management, park owner did not install the driveways. And, look, this can be a very difficult issue to navigate. How do we know who did it unless we have records from that time. We may not have records. What I always tell residents is go to your local county planning department and see if you can find any evidence of when the park was built, who is pulling permits, and is there any evidence that any grading or concrete work, was being done by the park owner at that time. Department of Housing in Sacramento possibly could have records, but frankly, they don't keep records for a long time there. And anything past maybe 5 or 7 years, that may not exist in Sacramento. One of the things I always tell residents is look around the park, look at all the driveways. If you see, in a 100-space park, if you see 50 asphalt driveways and 50 concrete driveways, or, some driveways that are aggregate or something, or even gravel, well, that would seem to tell me they weren't all built at the same time. They were constructed perhaps space by space as residents moved into the park. That would be indication to me that homeowners may have originally installed those driveways. But if you look through the park and all the driveways are the same, they're all, slurry or blacktop, asphalt, they're all concrete, they all look substantially similar, maybe except for a few driveways that we know have been replaced recently or that have been installed when brand new spaces were created. Well, to me, that's evidence that the park owner did install the driveways because they all look the same. And that would be evidence to me that when the park was first built, all the driveways were poured at the same time, and the park owner is the one who would have done that. I have always taken the position that in most parks, the park owner probably installed the driveways. And until they could prove otherwise, I believe that's a proper assumption to be made. Once you make that assumption, the law that I just read applies. Unless the homeowner causes the damage to the driveway, management's responsible for driveway replacement or driveway repair. I've heard park owners are somehow forcing homeowners to conduct costly health and safety inspections and remedy violations prior to sale or listing of a home. And the burden of proof is on the park owner. Question, what are the options of the homeowner? Remember, folks, when you're selling your home, the park owner has the ability to give you what's called a repair or upgrade list. But the mobile home residency law specifically limits that to the exterior of the home. They have no jurisdiction over the interior. They can't tell you you have to change your dishwasher out to sell your house. They can't tell you that you have to install new kitchen cabinets or new flooring in your bathrooms or new toilets or sinks. That's all inside the home. The MRL specifically limits their ability to require upgrades or repairs to the outside, things like painting, the railings, loose railings or improperly constructed steps or decks, grease on the driveway, dented awning supports in the carport, landscaping that violates park rules. Those would be the kind of things that the park owner is limited to. When the park owner says to sell your home, you have to get a full health and safety inspection, I believe they have absolutely zero ability to enforce that. I will say that in most cases, I think it's actually beneficial for a homeowner who's selling their home to get a health and safety inspection. I mean, you can get them for maybe 200, 250 bucks. And if you get it ahead of time, it's going to flag any issues that might need to be repaired. Because even though the park owner can't require repairs to the inside of your home, your buyer can. Your buyer could say, hey, I'm not going to buy this house with this dishwasher here. Either you replace it or give me a credit off of the purchase price. So it's probably a good idea for any resident who's thinking about selling, get an inspection if there hasn't been one for a long time, if you've owned the home for many years. See if there's termites there. See if you've got other, electrical or plumbing issues that you need to know about. But the park owner cannot require full health and safety inspections, and they certainly can't say you got to remedy all that stuff. The only time that I would say it's at all reasonable for that to happen is if you have a very, very old home. It's dilapidated. It's clearly significantly run down. There, the park owner could say, you know what, we're not going to even let you sell this house. It's so far gone. And under 798.73, which is found in the Article 7 resale or sales section of the MRL, 798.73 talks about the park's burden of proving what the code calls significantly run down or in disrepair. I think it's very difficult for the park to meet that burden. In that kind of case, they might say, if that's the allegation, they might say to the homeowner, well, we're not going to let you sell, and you can get an inspection and show us otherwise. There, the homeowner might say, we almost have to get an inspection. You know, we've got a 1960 single wide home. We got to know, is there aluminum wiring in this house? Is there something else that's beyond fixing? So that is what the limitation is. I get it. I see this all the time, interference with resale, park management giving these lists to people to fix all these things. And sometimes, again, it might require legal intervention because a lot of times you see a list of 10 or 15 things, and right off the bat, there's like 5 on here they can't even demand. Things like removing trees and making changes to the ground, which is also prohibited by the mobile home residency law. We had situations many years ago before drought conditions came to California, where park owners were requiring people to install living green sod and sprinkler systems in the lawn in order to sell their house. And we got a law passed that says, no, you can't make homeowners repair the ground or change the land itself that the park owner owns. So there are limitations, and sometimes you have to fight for them, and you want to employ a very capable mobile home dealer, salesperson, broker, or agent who will fight for you, and speak up, and dispute those things. Last question, pre-submitted. If a park allows subleasing and puts a limit on the amount that the homeowner can charge to sublease the home, does that mean the park owner has to also abide by the same limitations? Really good question, right? Because that comes from the law that was recently amended that says management has to follow their own rules, essentially. And the amendment that we just took specifically speaks to the issue of subleasing and says that a park owner cannot rent homes or sublease homes if they don't allow the homeowners to rent out their homes. If you take that section literally, I would say the answer is, if the park says, okay, you can sublease, but you can't charge more than X, then I would say the park owner is also under the exact same limitation. Practically speaking, that's not an issue that legislation that amended that section. It's actually 798.23. We didn't, we sort of intentionally stayed away on this initial piece of legislation from drilling too deeply into the restrictions or the conditions or amounts. What the park owner is going to say, of course, is in the very next section, which is the medical sublease section of the MRL, and that's in 798.23.5. In that section, added about a little over 20 years ago, which allows the 1-year maximum limited medical sublease. That section says that the homeowner can only charge the amount that they're paying the park owner for rent and utilities. So that's going to be, I think, an issue that's going to come up more and more, because I doubt seriously that parks will restrict themselves to the same limitations, and it may require even maybe a court decision or two to construe that. But I would say, yeah, if you're going to take that situation or the code section language literally, the park owner is bound by its own limitations. All right. And I'm ready to open it up to any questions from the floor.
Okay, before we do that, I just wanted to make a recommendation to all of you that a lot of the questions that come across my desk, certainly, and maybe a lot of questions that come to Bruce could possibly be answered by a GSMOL leader that you might know, or you may not know. So it's a good idea to know who your GSMOL go-to person is. If that might be a chapter person, chapter officer, or it might be an associate manager, a region manager, a zone VP. A lot of questions can be answered by these folks, and they can also help you find resources that you need to cope with some of the problems. So I just wanted to put that out there. And then I will go ahead and start taking the questions. Now, what I'd like to do, as I said earlier, is to start with people who have their hands up and alternate between anybody who is on the chat. And my co-host, Martha O'Connell, will be handling the chats. So we'll go back and forth in that manner. If you feel more comfortable putting your question into a chat, that's fine. And so we'll go ahead and start with Maria. Would you go ahead, please?
Hi, Maria.
Hi, I have a question. We got a notice that we are gonna start paying to use the clubhouse, $100 and $200 for deposit, and deposit is not returned. We have been with this issue for almost 2 years. I don't know if you recall that I asked regarding this, but the clubhouse, it has not been open. We only use it whenever we want to reserve. And also now the new manager saying that we cannot have parties, and that's the reason why they're charging. And that was never the case. Now, second question, I know for a fact that the Emerald.
Could I stop you? Could I just take the first question first and then go?
Go ahead.
Because, the answer, of course, for the relevant provision in the MRL is 798.51, right? And that's what we call the First Amendment rights of mobile home residents: to assemble, to meet, to canvass, or petition and invite speakers. And what it says is that you have the right to peacefully assemble or meet in the park at reasonable hours in a reasonable manner for any purpose relating to mobile home living, mobile home issues, or public interest, and for social purposes. And we know also that common area facilities, meaning laundry room, clubhouse, swimming pool, must be open and available, open or available at all reasonable hours. We also know from 798.51 that a homeowner cannot be charged a cleaning deposit in order to use the clubhouse for meetings related again to mobile home living, or for social purposes of the residents. And they can't charge you liability insurance for the use of the clubhouse unless you're serving alcohol. So kind of putting all those things together. The park can charge you if you're having a bar mitzvah, if you're having a funeral memorial service, if you're having a wedding, if you're having some kind of event where you're inviting outside people to come in, especially if it's like a family event and you're not inviting the residents of the park. That's not covered in the MRL. That would be a special kind of party or event, right? So they can charge you for that. They could say, we get to rent out the hall for those kind of things. But for a GSMOL meeting or any kind of club or group of people who live in the park, whether you're playing cards, you're doing crafts, you're having events where city council candidates are coming, right, to do like a candidates forum. Well, they can't charge you for that at all. They absolutely cannot charge you. No insurance, no cleaning deposit, no special fee. So I don't know if that begins to answer your question. I would need to know more about when you say that, we have to pay $100 to use the clubhouse. My question back to you, Maria, would be, for what purpose are you asking to use it? if you said, we want to have a homeowners association meeting or a GSMOL meeting, and they say, sure, you can have that, you have to pay us $100. Well, that's flatly illegal, absolutely illegal. And we've actually had a few of those cases. It's been some years now where under the GSMO legal budget, we actually had an attorney who got involved and wrote demand letters to those parks and got those restrictions lifted. And it might be the kind of thing that either myself as GSMO counsel or through the MRLPP program, right? A legal advocate gets involved if you have to. But I would want to know more about the specific nature of the meetings. If this is in writing, I would want to review it. I would say, get it to your regional manager or your VP so they could kick it up to me. And let's take a look at it, because what you say on the face of it is concerning.
They're not explaining the purpose of why they're charging or for what reason. But when I spoke with the manager and I gave him the civil code, he says, okay, but for any, like, let's say for a birthday party, yes, you're gonna invite your family that doesn't live in the park so that they can charge on that.
Yes,
Yeah, I didn't know that.
that's
And
a
then,
private event. Yes.
okay, also, the fact that now we have, according to them, an on-site manager, which we don't know when he's there. He's not there every day, and the clubhouse has not been open for service. So I already spoke with the new manager. We waited 2 years. It's been since COVID that we've been struggling with this issue. And now that that we have a manager, like 2 months ago, he's not opening the clubhouse. He says he's in there, but he's
Okay.
locked up.
Yeah, well, that's not proper. COVID is long over in terms of the emergency, regulations that were issued by local governments. There's no more issue about that I am aware of anywhere, thankfully. And if they just said, I know some parks said, this is great because now we don't have to pay maintenance for the clubhouse. We'll just leave it closed, or we'll just say, well, if you want to use the clubhouse, you have to contact us. And then nobody can figure out how to contact management, or they're never around. So I would say this, it's the same problem. 798.30 makes it very clear, or it's actually, I'll get the right reference for you. It's actually 798.24. Every common area facility shall be open or available to residents at all reasonable hours, and the hours have to be posted. Now, they might say we've had vandalism and so forth, and we're going to use like a key fob kind of system, or if you want to use it, just, you have to give us a buzz and we'll come over and unlock it or something. Maybe they could get away with that. But if they make all that too hard to navigate, or if they just say it's shut, it's done, that's a violation of the MRO. And they should be called on it. And again, maybe you file a complaint with the MRLPP program, because you can't just close the clubhouse. If the clubhouse is still there in the park, it's a common area facility and it's part of what you're paying rent for. So yeah, that's my opinion on that.
And that's what I'm doing, but it's been more than 2 years and they're still don't want to open it. I already called HCD like more than 3 times, and that's one of the things but it's still not getting done.
Well, calling HCD is not what you need to do. What you need to do is go online and file a complaint with HCD under the MRL protection program. Yeah, it's not a phone call. It's an actual written complaint that you make online. You can also give this information again to your local or to your regional manager, and it may be that under the zone legal budget, we can intercede on your behalf.
Okay.
Okay, thank
But
you, Maria.
That's improper. 2 years. No way, Jose. They shouldn't be doing that.
Okay. All right, Martha, can we take your first
Yeah, I'm combining two questions in the interest of time. One is from the former GSMOL president, Linda Nye, and also from Greg. They are concerned. Linda is saying she's seen more and more managers trying to stop sales and demanding the seller make repairs, even if the buyer is willing to purchase as is. Then they don't approve the buyers. What can be done? And Greg
Go ahead.
says,
Yeah, go ahead.
Greg says that for every one seller that is being approved, 5 to 6 are being denied.
Yeah, interference with home in-place resale is a huge problem area. It's a huge issue. It comes up all the time. Park owners are motivated by, well, it's an older home, we just want it out of the park, or we've got a sweet deal with one particular dealer, and we'd rather have that dealer be given the ability to own the home, pull it out, put a brand new home in. Or we want to decontrol the space. We have rent regulations in our city or county, and we know that if we can frustrate a resale, somebody throws up their hands and says, okay, well, I'm just going to walk away from my house, or I'll sell it to you for $5,000. So we know there's a lot of motivation for that. And again, repeating what I said in response to one of the pre-submitted questions earlier, the mobile home residency law addresses this in 798-73.5. Only the exterior is under the jurisdiction, if you will, of park management. And they cannot, if you say, I want to sell my home as is, their only objection can be to the exterior. They can't say, well, no, you can't sell it as is if we haven't inspected, the appliances inside the home. Unless there's a code violation, the only kind of appliance I think that comes into play is the water heater. They could require, if the water heater, which many times is on the outside of the home on the little water heater sort of compartment, if that water heater is not properly strapped, that has to happen. And that's a whole separate requirement in and of itself. But otherwise, they don't have jurisdiction on the inside of the home. And you just need to push back and say, no. If you're going to interfere with my sale and I lose my sale, you could be responsible for the lost proceeds. Is that what you want to risk, Mr. or Ms. Manager? You don't have jurisdiction on the inside of the home. If I want to sell my home as is, I can. It's between me and my buyer. Again, if I'm representing a buyer of a mobile home, I would never in a million years tell the buyer, just go ahead and buy the home without getting an inspection. I mean, to me, that would be crazy for a buyer to buy a home sight unseen and not even know what they're getting. So in my opinion, typically inspections get done by either both parties or at least one party, but the park should have nothing to do with that. And I would have to say this in closing. If I'm representing a park owner, I'm telling them you shouldn't get involved in that. Because if you get involved in that and start, talking about inside appliances and all the issues inside, and then anything is misrepresented, if the buyer wants to make a claim for that, who are they going to go after? They're going to go after everybody. They're going to go to a lawyer, and the lawyer's going to say, we're shooting bullets in every direction. And most of all, we're looking for a deep pocket. And if Martha sold that home to you and Martha's long gone, we don't know, she relocated to Vietnam. And so we don't know where she is now. Well, who's your remedy? The park owner. They're still sitting there. And then you find out, oh, the park demanded an inside inspection and they demanded, repairs. The park's involved. So yeah, I mean, I get it. It's a huge problem. It's an ongoing battle, and we fight it day by day. I've got a couple of realtor broker agents who I represent on a continuing retainer basis. And they're contacting me frequently saying, I got another problem. I need you to write a letter, or I need a conference with you to try to resolve this. And we just have to push and push. And most times management will back down or at least modify their stance. But I get it. It's a huge, huge problem.
Thank you. I'd like to remind everybody that we'd like to limit you to one question, please. If you have more than one question, then after everyone has had their turn, we'll come back around to you. So just please do that so that we can make sure everyone has time to ask their question. So the next person is the gentleman sitting in a window that says Michelle Oyao.
Yes, this is Don Oyao. I have a question regarding an incident that took place before just as I moved into our mobile home 3 years ago, and that was alluded to by that was talked about of a tree, and the tree that is this big pine tree grows in my property, of which we of course we pay a lease, and that tree extended a huge branch over our next door neighbor, who was concerned about the branch falling if it was going to fall. Anyway, she contacted an arborist who came and said, listen, we're going to cut this branch off because it's threatening your next door neighbor. I said, fine. Okay. And the arborist says, well, you're going to have to pay $150 to $200 or so for this branch to cut. And so since I was new in the park, I wasn't too sure exactly, but since that tree grows out of the property that I lease, am I responsible for paying for to cut down this branch? Who is accountable for that?
Yeah, good question. And the answer again is found pretty specifically in the mobile home residency law in Civil Code section 798.37.5. That section deals with trees and driveways, and I've always referred to it as the tree driveway bill that was passed when this took effect January 1st of 2001. With trees, it's not always easy, right? It's not always black and white. In this case, it sounds fairly certain, but management under 798.37.5A is responsible for the trimming, pruning, or removal of any tree that constitutes a specific hazard or health and safety violation. If there's no specific hazard and no health and safety violation, it's the resident's responsibility if the tree is on your rented space. So the resident's responsible for the rudimentary, trimming and thinning and cleaning up the debris on the ground, watering the tree, possibly spraying or keeping it free from infestation. But once there's disease, the tree's falling over, the tree's touching a home, the tree's dropping, large pieces, whether it's branches or, pieces of the tree, or if it's deemed to be a hazard by extending over a home, that's the park's responsibility. Pure and simple.
Unfortunately, or so I did pay that fee. It felt like I was coerced, and but I paid a fee because I was relatively new to the park and I wasn't aware.
Well, in the future, you see any condition like that, and actually getting an arborist is the right thing to do. Initially, what you want to do is give a notice to park management to say, hey, part of my tree is over my neighbor's house and they don't like the looks of it. And in the storms, it's moving a lot. It's very heavy. Stuff's starting to drop. I think that's a health and safety issue. And my neighbor and I are both requesting that you take care of it. And if they say, nah, it's your responsibility, the next thing I would do is get an arborist. And then if they still deny it, well, then you've got, an MRLPP issue, maybe a complaint, or you say, well, I'm going to send you a written notice that says, I'm going to take care of the tree because I don't want somebody to get hurt. And then I'll sue you in small claims court to get the money back.
Thank you.
Yep.
Thank you. Okay, Martha, over to you.
Donna and Merle, your question has been answered in the chat. Okay, there is a park that the rules state that if you're repainting your house, you have to use a neutral color, and neutral is not defined. The residents are telling me that the park manager is pushing that And when they go down to the office to talk about painting the house, they're showing 5 colors and told they have to pick one of those. Is that legal?
This is a pretty common issue when it comes to a discussion of a reasonable rule or regulation, right? Because we could certainly start off by saying, I think we could all agree it's reasonable for a park to put some restriction upon color. The example that I always use from news stories that we used to hear, somebody's football team would make it to the Super Bowl and they'd go out and they'd paint their house in the colors of the team. And if anybody is familiar with football teams' colors, they can be pretty garish. And we don't want, orange and blue bright paint for somebody in Denver who loves their Broncos painting their mobile home. However, there has to be, on the other hand, some kind of reasonableness to the limitation. And typically, in my experience, a park will describe the available or acceptable colors as earth tones rather than neutral. I guess neutral is also something you could use. And they will have a palette. They will actually have like a color swatch palette available in the office. And as long as there is a reasonable a number of possible color combinations, I would say there's nothing wrong with that. The problem would be if it becomes so restrictive that you only have, when you say there's only 5 colors, that's beginning to sound restrictive to me. And also my concern would be if you only can use this kind of paint, which by the way is only sold by this one, paint supplier that we happen to have a nice little sweet business deal with. And we refer, they give us a kickback for everybody who comes in from the park to get their house painted. You always want to guard against situations like that, where favoritism or some kind of tying is being, unlawful tying is being committed. 5 colors, I mean, I would want to know more about what that really looks like, but that's beginning to sound more unreasonable to me. I think that you could probably find more than 5 neutral colors or 5 earth tone colors. So yeah, in general, the park has a right to regulate color, but they can't do it to an over-restrictive manner.
Thank you. Okay, Mary Ann, go ahead.
Thank you, Bruce.
Hi, Mary Ann.
Thank you. What I wanted to tell you was that on May 8th, I found out that my rent check, along with 29 other residents' rent checks, were stolen from the outside rent box, which is one of the ways that we can pay our rent. I want to know what is the property manager's responsibility to us. I was charged a stop payment fee to stop payment on the check, and also I had to pay for new checks. Thank you.
Yeah, I'd actually responded to some email traffic about this one, Mary Ann, but I'm happy to, respond again here. First of all, I don't think management is going to be liable for unforeseen criminal conduct. Okay. I mean, the conduct itself, the theft itself, management's not going to be responsible for unless you could prove that this was an unsecure box, that they took no steps to secure it from a potential theft. They left it unlocked. It's like this other question I had where they said there's an unsecure box attached to a garden shed, which sounds really pretty ridiculous. I mean, if you're going to create a drop box, it needs to be the same way, in my opinion, maybe not quite as extensive, but the same way that a night deposit is created by a bank, right? I mean, you're going to use an ATM now, but in the old days, we had night deposits where, you could put your money, your deposit check into some kind of a slot, and it was well secured from theft to a reasonable extent, or the greatest extent that the bank could do. This isn't a bank, I get that, but if you're having some kind of a drop box, it does need to be in as many reasonable ways as it can be made, criminal proof, crime proof. So I would want to know what does that box look like and how secure is it? If they've done a reasonable job of, creating an outdoor slot and there's a lock box and somebody had to literally commit criminal mischief, to break into the box, everything from, like, we see these people that try to drive cars into ATMs, right, to get the money out. But just, if somebody could just walk up to the box and without much trouble at all access it, then I would say that could be negligence on the part of park management. But otherwise, the park is not responsible for criminal behavior or activity. The other kind of law that gets into that area is where you have grounds, certain grounds, common area grounds, and the shrubbery and trees, bushes are allowed to grow up so that people could hide behind them and jump out and assault folks when they're walking around in the common areas. There is clear landlord responsibility for not properly maintaining the premises in a secure manner. But I understand you're talking about, well, we had to stop payment on checks and so forth. Obviously, that's small claims jurisdiction. It's pretty incremental amounts. I'd be more concerned about whether this develops into a pattern, frankly, even more than the one-time event. But I think that's my take on that one.
Okay, thank you, Bruce. I'll send you an email. Thank you.
Thank you. Okay, Martha, back to you.
Yes, and I'm going to ask the person who asked the question in writing to ask it verbally, because I think Bruce is going to have a lot of follow-up, needs more information. So Eric, we're up to your question on the installation of the driveway. So can you please ask your question verbally? And is Eric Roa still in the meeting?
He says, no, I can't.
He can't.
Okay.
Okay, all right, then I'll read the question.
Okay.
Apologies, Bruce. Question: the park owner installed driveways. However, it was 2 strips of concrete still in okay condition. Problem exists that the ground / dirt down the center and on each side of the driveway has been landscaped or installed pavers, bricks, rocks by the homeowner. When the bricks collapsed, broken, making the driveway unsafe, is this the park owner's responsibility?
Wow, that's a real nuanced situation, right? Because it sounds to me like you've got a driveway base, if you will, originally installed by a park owner, but now you've got a homeowner making modifications to it and adding things. And if those modifications or things that have been added are the cause of the problem, then it's going to be the homeowner's responsibility. Because when you read the code section, it says the management's responsible if they installed it. But then it says the homeowner may be charged for the cost of any damage caused by an act of the homeowner or a breach of the homeowner's responsibilities. So I would say if it was the act of the homeowner to install pavers, to put landscaping on or near the driveway in such a way that has now created the problem, I think it's something you'd have to look at very specifically. This is a pretty unique situation in my experience, but it could be that the homeowner's responsible.
Okay. Okay, he says, thank you. All right, going on to George. Go ahead, George.
Hello, George.
Bruce,
How are you?
okay. I would hopefully you would illuminate us about senior overlay suits in California.
I think your question, George, is if a local jurisdiction such as yours in Thousand Oaks has passed a senior park overlay district zoning modification, what is their risk of being sued for that? And what's happening with any lawsuits that have been filed throughout the state?
What's happening with any lawsuits that have been filed? Yes.
Well, the first lawsuit that was filed was based upon what the city of Yucaipa did back in the 1990s when they created what I think was the first such zoning restriction to make a property by its zoning definition be limited to occupancy by housing for older persons, or what we call senior parks. And they were sued in federal court, and it went up to the Ninth Circuit Court of Appeal, and the Court of Appeal validated the city of Yucaipa's ordinance. So we start there. I'm not aware of any case that has ever gone by decision contrary to that opinion. I'm not aware of any. I am aware of at least one case that has been recently filed in the city of Petaluma, because I've been doing a lot of work with 2 rent hearings in that jurisdiction. And the park owners there, it's our friends at Harmony Communities and others who have basically, because the city made modifications to their rent ordinance that they saw as being very restrictive, they said, okay, we're going to start filing all these petitions. We're going to have rent hearings. We're going to sue you, claiming your rent ordinance is unconstitutional. And now they're suing, claiming the overlay is unenforceable. And their theory is that, well, like I believe happened with your park, if the park notices a rules change, and we know it takes 6 months for the rules change to take effect, if they notice the rules change on January 1st, and it's going to take effect on July 1st, and the city, prompted by the residents, enacts a senior overlay on April 1st, 60 days before the rule change takes effect, the park owner says, well, it doesn't apply to me because I noticed the rules change on January 1st, and you can't change the zoning once I notice the rules change, even though the rule doesn't take effect for 6 months. That's their argument in the Petaluma case, and I frankly do not see how that argument's going to prevail. I know that the city filed what's called a demurrer in the court that's actually going to be heard within the next 2 weeks. A demurrer basically says it's a legal so what when somebody sues you and the complaint doesn't make sense on its face, or it doesn't state a valid cause of action. You file this thing called a demurrer, which says, I don't even have to answer this thing. It doesn't even state a proper cause of action. And the city's theory is you can't ever win on this theory. I mean, if your rules change doesn't literally take effect until after our overlay went into effect, you have no case. So I'm aware of that. I'm not aware of any other case, as I said, that's ever outlawed them in any way or said they're illegal. And frankly, that Ninth Circuit case out of Yucaipa, it's called Putnam Investments versus City of Yucaipa. I mean, that's a Ninth Circuit Court of Appeal, right? That's one notch down from the United States Supreme Court in the federal court universe. It's a very strong case that validates senior park overlay, which is more and more of a concern around the state, where these management companies are saying, we can make more money if we go all age. So we want to convert our parks. It's happening a lot around the state. So yes, senior park overlay is becoming a valuable remedy. And I know, talking to the city attorneys in your town, who are very capable, I mean, they thought through all the issues, I believe, very carefully before they adopted yours.
Thank you.
And also in Santa Barbara, which had a senior overlay that they enacted about 2 years ago, Star Management decided that they're not going to, they're just going to ignore that. And they started saying, okay, this is now an all-age park. Well, the city of Santa Barbara sued them and won. So I think the cities and the counties are standing behind these ordinances pretty well.
Yeah, good.
Okay, over to you, Martha.
Can a park remove all, I'm not sure how to pronounce the word, defibrillators? Can a park remove all defibrillators?
Yeah, this is an interesting issue. I have a resident-owned park client over on the coast, and they asked me this question about whether they should, as a resident-owned community, install these defibrillator devices throughout the park, so that if somebody is out walking and they experience a heart condition, there's a very close by immediate apparatus that can be used to save their life. And the problem is, if the park installs it, the park takes on certain liability for it. In other words, they have to provide training to people so that people know how to use it. They have to supply adequate instructions on the little device, the panel or the little enclosure, however the devices. I don't know if I've ever actually seen them, so I'm not sure what they look like. And I could see that a park owner could say, look, we're not required to have these things. If we had them and now we want to take them away, it's because we've got some risk here. We just don't want to undertake, that risk. So I don't believe many investor-owned parks, where you have the conventional park owner would be dabbling with that. I think mostly it'd be resident-owned communities that would be looking at it. But you have to decide, if you're a park owner, do I want to install these things to offer an additional, elective protection to residents that I'm not obligated to offer, but at the same time take on that liability. So I think that would be why a park would say, we're not gonna have them.
Okay. All right. Next is Dale. Go ahead, Dale.
Thank you. Have a question with regards to how do we get rid of poor property managers? In other words, that managers that consistently, routinely, continuously violate rules. And my question is basically, in your experience, is the courts the only way to get rid of a property owner, or to force a property owner to get rid of his manager? Do we do it, in other words, also, would we use complaints to HCD? Just how is this process of getting rid of a poor property manager? How should we get started? And in your experience, have you seen property managers be fired, removed, replaced due to poor performance?
Yeah, what a unique question. I'm sure nobody on this call has ever had trouble with poor property management, right? I mean, we could probably have an entire town hall just about this question, but to try to answer the numbers of kind of sub questions that you asked there, Dale, I don't know that I've ever seen a court action used for the specific purpose of removing a manager, because I don't believe that residents have that literal legal power. The way that you would get a manager removed is, in my opinion, as I've seen it happen, where residents are just complaining, this manager's a tyrant, they don't care about the law, they don't follow the law, they're doing all this underhanded stuff. I can remember some parks where it was just constant, day after day, week after week, month after month, year after year about a manager. In some cases, that happens because you, the residents, organize and you communicate to the property management company or to the park owner directly the risk that this person is creating for them. In other words, if somebody sues because the manager ends up assaulting somebody, or ends up, injuring somebody because they're always drunk and driving golf carts around the park or vehicles, and someone's really going to get hurt, or they're enforcing rules or not enforcing rules in a way that's contrary to the mobile home residency law, or whatever it might be, interfering with sales, taking kickbacks. Once you start communicating the risk to the employer that their employee is posing, that should really ring off some warning bells. And I've seen cases where management has reacted to that and has actually removed somebody who is creating that risk for them. If within the course of their employment, the employee while they're on the job, especially, is, assaulting and battering people, or sexually, harassing people, or they're a peeping Tom, or they're, again, injuring people. They're not going to be the primary pocketbook, if you will, that the injured person's going to hit. They might be the primary wrongdoer, but the primary money source, the deep pocket, is going to be the park owner or the management company. So they take a significant risk if they keep somebody in their employment, who's doing these things. Now, we also know that there are times when they're doing exactly what management wants or the park owner wants. Yeah, I hired you to be operating on the edge. I want you to be. And in those cases, it may not be possible by a letter or a series of letters to convince the park of the risk. You also want to do it in a way where you unite as many homeowners as possible, and you create very clear facts, that show exactly what's going on. This manager is out of control. I mean, I've written letters to upper management or park owners before saying, look, I'm putting you on notice. This is what happened. The manager is poking fingers at people and touching them. He's threatening to take a swing at people. He's, derelict in duties or negligent. You're going to be your client's going to be responsible if you don't do something about it. And you're on notice. The real key is you want to put the park owner and or upper management on written notice of this, so that in the event that anything does happen that causes damage to somebody, that's going to be part of the evidence.
Yeah.
And if you word your letter correctly, and again, it's not coming from just Dale, it's coming from Dale and 5 or 10 or 15 or 20 other people that are all experiencing this conduct. If you word it properly and saying you're on notice, we know that this is a contract between you and them. We're not part of the contract. We have no literal legal power to fire your manager. Only you can do that. But we're putting you on notice that if you refuse to either A, meet with them and conform their conduct and supervise them a lot more closely, or B, replace them, then you're on notice, and you could be liable for whatever's going to happen because you're going to let this manager keep going. The only thing I say is this: in some cases, and a couple that I can think of, it's one of those things, be careful what you ask for, because you
Yeah.
end up with something even worse. And I can
Yeah.
think of 2 situations where that actually happened. But the one that I remember the most, it was a park in Morgan Hill. I'll never forget it. And they just complained for years about this lady. And it turned out, after the residents began to just question her performance, the park owner finally started auditing and found out that the manager was skimming and embezzling from the park owner. And suddenly, just without any warning, one day they just showed up, emptied her desk, she turned in her keys, and she was gone. So sometimes when you notify the park owner about certain things and they just begin to then wake up and say, maybe we should just look at the overall performance, it may actually turn up something else that works in your favor, where the park will act not even because of what you're saying, but because of other things they find out. But I get it. It's an ongoing issue. And I would also just say the management training bill that I mentioned, that's going to come online, the regulations are to be published in about 11 months from today. And then it's going to come online, mid next year. Hopefully that will begin to offer some further protection as we provide actual training for park management, educating them about the mobile home residency law, the health and safety code, Title 25, which is the building codes and standards for mobile home parks. There are just too many parks still that are hiring these people who don't know anything about these laws.
Right.
And act like they either don't exist or they don't care. And that's just an ongoing battle that we fight. The last 35 years of my practice have specialized in trying to level the playing field for mobile homeowners and keep them in their homes.
All right, thank you.
Thank you.
Sure.
Okay, Martha?
Yeah, this is a question that I've been asked by two people in the last couple of days. I told them I would ask you, Bruce. They
Okay.
want to know, how does changing a park to a family park from a senior park equate to the park owner being able to make more money? What's the correlation there?
Yeah, and we'll call it an all-age park is another way to
Okay.
go. How does it equate? Well, I think that, and I haven't done a real study on this, but I think the perception is, number one, if I want to add spaces to my park, it's going to be more conducive to do that in an all-age community where there are larger families, more people coming in. I can have more density. I can create more spaces. And if I create the space, it'll be much easier to rent it. You know, that's one thing I think of right off the bat. Another thing is just, again, the income that a family is going to be able to make is going to feed into the narrative the park owner will take to a city council, to a board of supervisors, that these are not poor people. They don't need rent control. They don't need rent stabilization. They got a double income here. They're making tons of money. They're not vulnerable seniors. It's part of that whole narrative to protect themselves against, regulation. And if there's no rent regulation, hey, you got people that are more actively employed, then you can charge them more rent because they can afford to pay it, in your mind. As well, I have to believe that there is a feeling that in an all-age park, the adults occupying the home are much more distracted with life. They got kids, they got school issues, they got work issues. They get home at night, they're tired. They don't want to go to a GSMOL meeting. They don't want to, get involved with some of the kind of issues we've been talking about. In their experience, I think the more likely suspects to be the troublemakers, the rabble-rousers like Martha and Anne, they're going to be the people that are retired. They got time. They've lived a little bit, and they got time to actually watch out for their friends and neighbors. They're not, worried about, climbing the ladder at work or PTA meetings and, getting their kids' homework done. They've got time to look around and say, these people need help. We need to do something about what's going on here. So, I mean, those are just a few things that I throw out. Also, I think that if it's an all-age park, my perception and maybe my understanding would be that the park will increase in value in terms of its saleability and also its ability to attract capital and get loans if they wanted to refinance their loans. So yeah, those are my thoughts about that.
Okay. Okay, Greg, go ahead.
Yeah, I have a question on earlier you talked about lot lines, and is there a requirement for the park, or do they have to publish or define how they lay out these lot lines, or is there any standard for that? And also, is there a requirement, do they have a certain amount of common area for the number of units in the park?
As to the second part, Greg, I'm not aware of any such requirement.
Okay.
Of any kind of minimum common area. As a matter of fact, I just did a rent hearing for a park in Petaluma where, amazingly enough, with average rents of $495 in a very small low-income park, the park owner wanted to raise the rents by $1,500, believe it or not. But that park has 2 streets, 78 spaces, no clubhouse, a tiny little patch with a square of grass that literally you couldn't play pickleball on, a laundry room, and a little tiny pool. The common area percentage in that park compared to the rest of it is infinitesimal. So yeah, I'm not aware of anything like that. As far as lot lines, the Health and Safety Code has a specific section that says lot lines must be, or lot markers is really what we're talking about, must be clearly defined. They must be permanent and they must be visible. And it doesn't say lot line because basically as long as you establish markers, the lines come naturally from those 2 points, right? So yeah, there is a health and safety code that mandates that. And if the park is inspected and lot markers are not visible and clear, they could be cited for that.
Okay, because we have no lot markers at all.
Yeah, well, lot markers are going to be at the front of the home. It's going to be a notch in the curb typically, or maybe even a pin sunk into the concrete when the gutters are poured. That's fairly commonplace. The problem usually occurs with the rear markers.
Yeah.
Especially where you've got parks where some of the spaces look like jigsaw pieces because of what's happened over the years, probably a lot illegally where stuff's been shifted around. The rear markers, if they're not like rebar in the ground or a pin in the ground, I've seen situations where the HCD inspector will look for anything historical, maybe even a tree or some kind of a wooden post, anything that they can guide off of. There also, when you create a space, there has to be a plot plan that's approved by the state. Again, the problem is one of the things that kind of frustrates me, even though we are living in a digital world, is the Department of Housing does not keep records long-term. And so we don't always have access to the plot plan that has the dimensions of the lot. But you would want to find out in my park file at the office, is there a plot plan? Is there a plot plan at the state? Is there a plot plan at the county that might have gotten filed when we were putting utilities in, or otherwise, mapping out the park for occupancy? There has to be a way to designate your space. And if you're saying in our park we don't have any markers, I would say, how do people even know where their space is? Is it by landscaping or the
Yeah, basically the manager will just say it starts at the edge of your carport and goes to the front of the next carport. Behind you, where there's 2 mobile homes butting up against each other, if you look down between all of them, you'll see they're jagged left to right because some people have long mobile homes, some people have narrow mobile homes. I asked her, well, is it supposed to be a line straight down? Or because I have a longer mobile home, I get more lot? And she goes, oh, nobody knows. You're just asking too many questions. I said, well, but they're trying to assign trees to people behind their mobile homes based on imaginary markers that I can't find.
Yeah, that sounds like a mess. That sounds like a problem that's been waiting to happen for a lot of years. Everybody just ignoring it. But if your park is inspected by Department of Housing, whether the residents request the inspection on your own because of these kinds of issues, or whether it just comes up naturally in the rotation, in the 7 to 10 year rotation in the MPM program, if they come out there and there's no lot markers, they should be citing the park for that. And then, of course, the problem is then you don't want newly created lot lines that suddenly create, oh, now we have encroachments.
Right.
And then residents are going to say, well, that's nice because this is what you told me and I landscaped based upon your verbal representation, and now you're telling me that's not even part of my lot. Then we got other issues that crop up. Yeah, that's an accident waiting to happen.
Okay, thank you.
And by the way, lot lines are not determined, spaces are not probably ever determined by the length of a home because that could change.
Right. That was my understanding.
Those spaces are laid out and the dimensions are established before any home ever moves onto the space.
So does the park have to let us know somehow to have a record of what they were at one time or what they decided they are?
It's a perfectly valid question to ask them and expect an answer for, in my opinion.
Yeah, I'll write them. Okay, thank you.
Yeah, that's what I do.
Okay, so we're now past 2 hours, Bruce. And so can you take a couple more questions or do we need to
just
stop?
a couple more if we could. Yeah.
How about you, Martha?
Okay, Ethel, your question is answered in the chat. Next question, arbitration versus mediation, which is better to resolve rent increases or other disputes?
Well, that's a question that's hard to answer, black or white. Mediation is the voluntary discussion with maybe a third-party mediator who's moderating the discussion to see if the parties can voluntarily reach agreement. Arbitration is when a hearing officer is actually hired to make the decision. In many rent ordinances, there is only arbitration. In some ordinances, there is also a requirement to try mediation first. Whether mediation is better, it sounds like it could be better to sit down and have a rational, voluntary discussion, but I would say that's going to depend on the residents to some degree, but it's also going to depend on the park owner. There are some park owners that I would have no trouble going into mediation with. There are others that I wouldn't touch that with a 10-foot pole, because I know it would probably be meaningless. It would just be a waste of time. There are some park owners who frankly don't understand anything other than we will have an independent arbitrator acting as a judge make a decision. But an arbitration is more formal. It's a presentation of evidence. It's a hearing. Mediation is a voluntary discussion. So, if it's a rent increase application and they want, $100, and you think that your park owner is rational and reasonable, and we might be able to negotiate with them, and let's talk about $50 or $25, mediation could be great. But, in a park like I just mentioned, where the average rent's $495 and they want a $1,500 rent increase to take the rents to $2,000 a space, I would probably say mediation probably doesn't have a lot of chance of success there. So it really kind of depends upon the facts. Mediation is great if it can work. Yeah, it's a good alternative to a more formal hearing.
Okay, we don't have any more hands up, Martha. So
Yeah,
go ahead.
last question in the chat. Is one or the other, arbitration or mediation, have less risk of obligation to pay the winner's legal fees than small claims or other such judgmental or litigating decisions? Sorry.
Well, it just, whether you're responsible for prevailing party fees just depends upon the basis for it, the law. The mobile home residency law prevailing party fee shifting provision applies to any kind of action, small claims, superior court, court of appeal. It applies to any court action. If you're mediating with somebody, then there's probably no responsibility to pay anybody's fees because it's a mediation. You haven't gone to court yet. If it's an arbitration, there may be responsibility. It depends upon what the law says or what the rental agreement says about prevailing party. And I saw a question there in the chat from Eric about, does the bill, it's actually, I think the bill, the Roth bill about work vehicles, is there some kind of weight limit attached to the vehicles? The answer is no. There's no commercial weight limit that I recall. Okay.
All right. Thank you, everybody. And thank you, Bruce. And thank you, Martha.
Yeah, it's
And-
always fun being challenged with these great questions.
Yeah, we like to play Stump the Lawyer. And
Yeah.
there'll probably be another one
Stump the lawyer.
in a few more months. So just, I hope that you'll be all there for that. So thank you very much, everybody, and have a wonderful day.
Thanks, everyone. Take care.